I've had the pleasure of representing Rhonda K. Davis since at least 2017. I've represented her in the Coffee County related matter.
Counsel, did you want rebuttal? I'm sorry.
my
You were not here at
apologies.
the beginning, so if you want it, we need to let the clerk know.
My apologies. I should ask for 5 minutes. I'll ask for that. Thank you for reminding me, Judge Steyer.
Thank you, Judge Ayers.
So I've had Ms. Davis as a client in 3 matters that were all related, and I've laid out in my brief. The main ones before your honors today. The other one, it was in the U.S. District Court, where we were successful in having her eventually determined incompetent, and Judge Collier dismissed the criminal charges. And I represented her in Coffee County, and I was able to convince the prosecutors there to dismiss those cases based on her competency. Which leaves me with the post-conviction matter, and unfortunately I did not have this matter prior to her plea in November 7th, 2017. But I'd like to start off with a focus on issue 3 and point out 3 very important dates in this case. The first one is August 15th, 2015. That's where Rhonda, or Ms. Davis, was arrested by Coffee County deputies up in Manchester at the Rite Aid. She was severely injured and was beaten, had severe head injuries, and I've laid out in my brief, and the record shows a long history of mental health treatment, which required her to go to 2 hospitals. One was the hospital locally there, and the second one was a level 1 trauma center in Murfreesboro, and these were all directly tied into her head injuries. The next critical date is June 30th, 2017. That takes us to Dr. Raffelli's evaluation of Ms. Davis and the findings there, and I'll get to that more in a minute. And then finally, the next critical date is November 7th, 2017, where Ms. Davis entered into a plea. Now, why are these dates critical, particularly with issue 2? We believe that the trial court made a mistake in disregarding the testimony of the family. Judge Sherman specifically had stated that there was all the testimony from these persons and all the documents that I attached from Dr. Apeso, who handled the evaluation in the federal matter at FMC Carswell, Texas. All of this, everything that everyone talked about, including Dr. Apeso, occurred after the plea. And with much respect to Judge Sherman, I believe he just was completely mistaken, and here's why. The testimony of the witnesses, all the family witnesses, was that they noticed a marked change in Rhonda Davis after the beating. In fact, Barbara Meeks, her mother, had mentioned that when they saw Rhonda in the ICU up in Rutherford County, that her eyes looked like they were bugging out. She almost looked like Garfield the cat. I guess that's the cat that she was referring to, the big eyes. All this information was imparted to Ms. Pirtle, who was trial counsel in that matter. All that information was imparted to her, not only from Ms. Meeks, but from Ms. Comer and from Mr. Siebert. These are family friends and relations, but they're the ones that have the best information initially to report what they saw of their loved one.
So Mr. Flores, help me with this. So the ultimate claim is that she was not competent to enter a plea. Is that right?
Absolutely, Judge.
Okay. And so the standard for incompetency is that I am unable to understand the nature of the charges against me. I'm unable to work with my counsel in the defense of my case. What was it that the family members themselves observed that their testimony would have been relevant as to the legal standard for incompetency? Not that maybe, she's a little different, maybe a lot different. She's a lot different after the beating that occurred in 2015. But how does that weigh into her ability to understand the nature of the charge against her? How does that affect her ability to work with counsel in the defense of her case?
Yes, Your Honor. If we look at the testimony of these family members, it's almost like someone flipped a switch on Rhonda Davis. She was once someone that was vibrant, that was engaging and outgoing, and all of a sudden was withdrawn. And to use some of the terms, I think it might have been Ms. Comer, that Rhonda wasn't there. She was just not there.
Okay, so she's withdrawn, but that doesn't necessarily speak to her ability to comprehend, that doesn't necessarily speak to her ability to work with counsel.
Very respectfully, Your Honor, it does give a signal, like Mr. Neil Pinkston, who was the expert in this case, a former district attorney of Hamilton County, testified that this type of anecdotal testimony or information from family members can assist the defense attorney in making a determination, hey, we probably need to check this out.
Okay, except that the defense counsel in this case testified that there was no inability to communicate or work with the petitioner here. Trial counsel also testified that the petitioner had awareness of the nature of the charges that were brought against her, and the trial court credited that testimony. And I wonder if just having the family members testify, well, she was withdrawn, she's completely different, she's not as outgoing as she was, undermines trial counsel's testimony to the point where it becomes incredible now.
But, Your Honor, it takes me to issue 5,
Okay.
where, we're talking about credibility. I've laid out the standard review for this court from the Kelly decision, and that standard of review is de novo without a presumption of correctness. And so what we have to look at here are the facts that we can actually hold in our hands, which I'm going to do now. It seems implausible to me that Ms. Pirtle was 100% correct or being, with full candor to the court when there is an order that she had put down for a psychological evaluation. Now, what the transcript reads for itself. And
She explained why she did it, though, right?
She did, but there's a problem that at least I have with that. Like, hopefully the court may be able to see it. Is if you're entering into a order for a psychological evaluation and transport, what was the purpose of that? If you're hiring Dr. Raffelli just to check her out to see if she fits, and I'll use some of the terms that Ms. Pirtle used, if she's a sociopath or redeemable. Why would it take an order like we see and Your Honor had seen on the bench in Hamilton County over and over again for transport and to have an evaluation done? That would suggest that there was some issue with the ability of the defendant to understand and comprehend and be able to assist trial counsel in her defense. Why, if it was just to hire someone for $600 to see if this person's redeemable, why not have Dr. Raffelli come to the jail to do that? Why would it take a taxpayer expense in order for the sheriff to run her up to Murfreesboro to have this, evaluation?
Well, that happens routinely.
Pardon me?
That happens routinely, doesn't it? I mean, they don't, in my experience as a trial judge, I don't remember any of the psychological experts coming to the jail to look at someone. There was an order to send the defendant for an evaluation, and you wait on the report. But just every time someone went to be evaluated certainly didn't mean they weren't competent. I mean, it depended on what the professional said. And just because the lawyer sends someone for an evaluation, are you saying that means that lawyer thinks they're not competent?
I would suggest yes, and here's why. Because you have family members that, again, presented very specific information to Ms. Pirtle as to the marked changes in this person. And why, again, have a order go down for transportation for the sheriff to take this person unless the attorney believed, well, maybe there's something going on up here. It takes us also to the other issue or the other information we got from Mr. Pinkston, who was the expert in this case, as to the information that was imparted or not imparted to Dr. Raffelli. Dr. Raffelli never spoke with any family members, was never provided medical records, never not given any other information from Ms. Pirtle other than she's got a drug history and probably needs, to be checked out. And what's remarkable from Dr. Raffelli's report and her testimony was, everything she said that she was supposed to check her out for and to recommend treatment.
Well, help me with this, and let me go back to the forensic order again. I mean, the nature of the forensic order, was it for competency evaluation? Was it for diminished capacity? I thought it was to determine if the petitioner had a personality disorder. Is that right? So I mean, the forensic evaluation wasn't for competency, was it?
Your Honor, and that's
Or was it?
that's the big question here.
Okay, well, if it's still a question, that's a problem.
Well, yes, Your Honor.
No,
but-
go ahead, Mr. Flores, I'm sorry.
But I do have the order.
Sure, what was the order specifically for? What was the evaluation for?
Order for psychological evaluation and transport. This matter came to be heard on the 24th of March, 2017, and the 23rd of June, 2017, upon this case being for review. Upon the announcement in open court, we don't have that. We didn't have that to get into the record here. By Assistant District Attorney and Counsel for the Defendant appearing satisfactory to the court, it is ordered that Rhonda Davis shall be transported by the Grundy County Sheriff for a psychological evaluation, whatever that means, we don't know, by Dr. Raffelli, located at 403 Uptown Square, and then it goes on that the sheriff will transport given a particular time.
Okay, well, so what that's saying to me, Mr. Flores, maybe you can help me with this, that's not referring the petitioner for a competency evaluation. That seems to me to be referring for maybe some kind of sentence mitigation, some kind of negotiation in a plea context, which is what I think trial counsel testified was the purpose here. So, I mean, just the mere fact that a forensic mere fact that a referral for psychological testing, that doesn't speak to competency, does it?
I
Not
think
the
it
mere
does.
fact. We'd have to have something more than that, right?
I would think so, but, again, that's the question, I think is countered by Mr. Pinkston's testimony and by the testimony of the family members. Mr. Pinkston was very clear that, hey, this should have occurred to be explored. If we were to look at the ABA standards in dealing with
But counsel is having conversations with the client. So counsel has some engagement with the client. Counsel can get a feel for, back to Judge Greenholz's questions, are they going to be helpful? Do they understand what we're talking about? And if counsel doesn't see that as an issue or see that popping up, then why would counsel ask for a referral for competency? That being said, counsel could say, hey, it's clear you have some mental health issues that we could use down the road for sentencing, and so I'd like a psychological evaluation, but you are still very capable of understanding what's going on and being helpful in preparing your defense. Those really are two different, you can have one without having the other.
And maybe to piggyback off that, and but we'll let you answer, I'm sorry, Mr. Flores.
Yes.
But what I understood from the argument is that trial counsel's testimony was not credible because it was contradicted by the fact that she sought a psychological evaluation. But the psychological evaluation on its face doesn't refer to competency. And in fact, I think the doctor was never even asked to give a forensic evaluation as to competency. So how does any of that weigh into the petitioner's ability then to understand the charges that were brought against her and then to knowingly and voluntarily enter into a guilty plea?
And again, that goes back to the credibility issue, Your Honor.
Okay, but the credibility finding was made against the petitioner. So how do we get there?
Okay. We look at a couple of things here.
Yes, sir.
Let's put Mr. Pinkston aside. Let's look at the fact that what occurred, at least with my efforts from U.S. District Court, that began shortly after all this. There was a consistent set of findings, not once, not twice, not 3 times, not 4 times, not 5 times, but 6 times by a forensic evaluator at FMC Carswell. The same thing, that this person, Ms. Davis, was unable to comprehend certain things.
And that was 2 years after she entered the plea in this case.
It would
Is
be.
that correct?
It would be, Your Honor, but what's consistent is that Dr. Raffelli, on one of those important dates, June 30th, 2017, testified that her findings, what her observations of Rhonda Davis was consistent with Dr. Opesso's findings, were consistent. That was her testimony. Her testimony, and our expert, by the way, Mr. Pinkston's testimony was not rebutted. And the trial court, for whatever reason, decided to disregard Mr. Pinkston because, I see my time's up. If I could finish this thought.
You can finish your thought.
Thank you.
Yes, please.
Decided to disregard discount Mr. Pinkston's testimony because he didn't talk to Ms. Pirtle. I was unable to find any direct authority that, an expert in Mr. Pinkston's position had to talk to Ms. Pirtle. I was an expert in the Barnes versus State of Tennessee matter out of Cleveland, Tennessee, a few years ago. I never talked to the public defender because I didn't think the public defender, for example, would be completely honest with me when you're looking at a possibility of violating the rules of professional conduct, like competence and diligence, in particular in this case. And so why would I talk to someone that have a vested interest in covering themselves? I look at the record. I think what stands out here, Your Honors, is the fact that we have a before and after shot. We have Dr. Raffelli in 2017 making her findings, and then her testimony saying that her findings or her observations of Ms. Davis were consistent with the other findings of, as Your Honor points out a couple years later. Nothing has changed. And I'll close with this. A person doesn't have to be frothing at the mouth or whatever to at least kick something off to trial counsel. Again, that goes, I believe, to Ms. Pirtle's credibility, and she completely disregarded what was told her by family members. And unless
yet
there,
the post-conviction court found her testimony credible.
yes, Your Honor. Unless there are any other questions.
Thank you, Counsel.
Thank you for allowing me to go over.
General.
May it please the court, Lacey Wilbur on behalf of the state. Your Honors, we kind of jumped around and addressed several issues. I think the main one was the petitioner competent to enter her guilty plea on November 7th, 2017, and yes, she was. So as Your Honors noted, that all these findings of mental incompetency occurred 2 years after. And the federal evaluator who said, I find her to be mentally incompetent, said, I can give no opinion as to her mental competency on the day she entered her guilty plea in this case. And in this case, we did have a little exchange where after the prosecutor recited the facts, the judge said, are these as you think? And she said, I don't know. And so they pressed, they had DNA evidence, and Ms. Pirtle, trial counsel, said she understands, she knows what's going on, this is in her best interest. And then the petitioner said, yes.
Do you think that the standard by which we judge attorneys for their effectiveness is below the reasonable standard to send someone for a psychological evaluation, but not while they're there, check to see, hey, are they even competent to stand trial?
If they are giving no signs that they are mentally incompetent, that attorney has no reasonable reason to put that person to that. And if this person is indigent, I know this from my time at the AOC, you have to jump through some hoops to show why you think they are incompetent.
Well, help me with that, because it was curious to me a little bit. I didn't think the state paid for an evaluation unless it was to determine competency or diminished capacity.
Ms. Meeks paid $600 for this
Okay.
evaluation.
Gotcha.
And
Okay.
on this
you.
evaluation, we have uncontroverted testimony from the trial counsel and the evaluator herself. This was not a competency evaluation.
Sure.
The prosecutor in this case was not willing to come to the bargaining table because she also had a pending county for also another violent robbery of a pharmacy in that county as well, not coming to the table. Trial counsel said, I went to get her this evaluation to show that she was human, that she was not some sociopath who had some pathological disorders, and that she was redeemable and she could be entering into a guilty plea and the prosecutor could be good with this. And
Yeah,
that's
because
exactly
on
what happened
probation.
in this
Right.
case.
So, but the assumption must be right, that because the petitioner was found to be incompetent in subsequent proceedings 2 years later, I think the assumption must be that she was incompetent 2 years earlier at the time of the guilty plea. And I don't see clear evidence, certainly don't see clear and convincing evidence in the record here. I mean, as you say, the forensic evaluator 2 years later indicated that she could not opine as to that at all. Is there, what other evidence in the record is there? Your friend suggested that, I can't remember, you'll forgive me, I can't remember the evaluator in the state court proceeding, but that her findings were consistent later with the incompetency. Can you speak to his argument there, please?
It's Dr. Raffelli.
Raffelli, that's it.
And
Thank
she
you.
testified on cross-examination, yes, the petitioner was showing mental deficits, but does mental deficits rise to the level of mental incompetency to where you cannot enter a knowing, voluntary guilty plea? And the answer is no. There's no showing of that in the
No
record
showing
whatsoever.
that. And Dr. Raffelli did not interview the petitioner with respect to the facts and circumstances of the crime itself.
Correct. The trial counsel said, I don't want you to go into that because that's confidential and we're doing this just
Right.
to go forward.
Okay.
And again, even if the family saw that the petitioner had a marked difference in personality, again, that does not rise to the level of mental incompetency to enter a knowing and voluntary guilty plea. And I think that's what you were pointing out with my friend on the other side. Your Honor, I have nothing more to add unless you have further questions. We ask that you affirm the judgment of the post-conviction court. Thank you.
Thank you, General.
Your Honors, I think another triggering event is my third one that I had listed would be in November 7th. Having been armed with some information from the family about Rhonda's abilities or lack of abilities, November 7th stands out in stark contrast to Ms. Pirtle saying, oh, everything's all peachy keen. And that speaks for itself, and it goes into the dialogue between the court and Ms. Davis. I don't know about all those facts, I'm paraphrasing, and that I only know what I've been told. The question would be right then, this was actually on the day of trial, by the way, trial was supposed to start. The question would be, why would Ms. Pirtle not stop and take a recess and find out, what are you talking about? I mean, I can only speak to myself. I had a client doing that at the podium. We'd step off and discuss it a little further. It sounds just from that dialogue that something was wrong there, something was going on. It wasn't explored any further, which takes me back to the ABA standards that I had cited on page 42 of my brief. Counsel must conduct appropriate investigations, both factual and legal, and I won't burden the court any more than that. It's on page 42, and that's where we're starting, and it comes out of State v. Burns, quoting Baxter v. Rose, that the attorney once armed with some kind of information, and then the day of trial, when all the cards are on the table or everything's ready to go down, hears that from a client and doesn't do anything further to explore it. And I would like to go just touch base on.
But wasn't the explanation there from trial counsel, though, that the petitioner was embarrassed? That the petitioner didn't want to, because family was in the courtroom, the petitioner didn't want to essentially confess to all of that in front of her family?
And unfortunately, you have just Ms. Pirtle's testimony on that.
Which
Well,
was
but-
credited, right?
But didn't the post-conviction court say, I'm looking right at the post-conviction court's order, that it was concerned upon just reviewing that part of the transcript. But then when you read the whole transcript and not that section taken alone and out of context, when you read the whole transcript, a review of the entire plea coupled with Pirtle's testimony at the hearing addressed any concerns to the court's satisfaction. So again, is that not the post-conviction court accrediting Ms. Pirtle's testimony, trial counsel's testimony, about what happened at that plea colloquy, and that it was satisfied? There was no concern.
And Judge Sherman wasn't the judge that took the plea. It was Rusty.
Understand?
I use his nickname. but it was,
Judge Graham.
Judge Graham, Thomas Graham. And it would seem that the only person that was talking, other than Ms. Davis, and what we could read, was Mary Pirtle. And again, we got an issue with her testimony as to what she did and didn't do in disregarding the information given to her by family members. I mean, Ms. Pirtle didn't even pull the first medical record. Says something, fleetingly about, well, I looked at some incident reports from the Coffee County case and didn't take all that in consideration when you got your client sitting there, oh, I don't know about all that, or just what I've been told. That should have stopped, at least, the duty on the attorney. Let's stop this, let's find out what's going on here. Maybe something else needs to be done, not on the day of trial or a plea's going down. And it will also take me back to Mr. Pinkston's testimony about that plea in of itself. There was nothing in there, nothing about assurances, about how that plea was going to go with the Coffee County matter. There was some discussion about it. Ms. Pirtle's testimony was somewhat vague on cross-examination, as why would you, did you have discussions with her about the impact on Coffee County? Effectively, you're looking at a 24-year stretch on both those cases. Throw in relevant conduct issues on a brandishing and Hobbs Act charge over in federal court that was floating over her head. Ms. Pirtle doesn't address any of that. It seems to me, Your Honors, that Ms. Pirtle got her money, pled her out in the day of trial, and that was it. Unless there are any other questions from the court, I'll go ahead and take my seat.
Thank you, Mr.
Thank
Forrest.
you.
It's good to see you again today, sir.
Okay, it's good to see you.
Yeah, thank you.
I think that concludes our docket. Yes, Your Honor. So we will stand in adjourned until the calling of the next docket.
All right.